Okay, thank you very much. Yesterday, we could feel enthusiasm as well as the hotness of the topics from the panelists as well as, audience. So I hope, this kind of mood will continue on over the whole sessions of today. In order to deal with the role of international actors in transitional justice, we have three distinguished scholars at this panel. Next to me, Professor Ndulo. He is professor of law at Cornell Law School and director of Cornell University's Institute for African Development and an internationally recognized scholar in the fields of constitution making, governance and institution building, human rights, and foreign direct investments. And next to him, Professor Ruti Teitel. She is our keynote speaker for this conference, and she is the Ernst C. Stiefel Professor of Comparative Law in the New York University Law School, and she is the author of Transitional Justice, which was published in 2000 by the Oxford University Press, and many articles and book chapters on international and comparative law, often focusing on political transitions. And next to her, Professor Andrew Reiter. He is an assistant professor of politics at Mount Holyoke College. His research focuses on understanding the effectiveness of policies that reduce violence. First of all, we have three international lawyers and one political scientist. I think, this would be a very interesting session. It's kind of interdisciplinary discussion. So first of all, I would like to give microphone to Professor Ndulo, who will talk about transitional justice, international and domestic courts, and response to human rights violations in post-conflict societies. Professor Ndulo, please.
Yeah, thank you very much, Chair. And thank you to the Asian Institute for Policy, Asan Institute for Policy Studies for inviting me to come and join you in this discussion. This has been a great learning experience for me from yesterday. Now, I have a paper, but I will not really sort of take you through the paper because you can read that in your own time. But I would like to highlight some of the observations that I would like to make in discussing this issue. And what I want to do is take from what Professor Teitel did yesterday, in terms of giving us an excellent, keynote speech, which highlighted the issues that we ought to be looking at. And then I will later try to look at the lessons learned from a number of processes that have tried to address this question of post-conflict societies. I think the first thing we have to be clear is what characterizes a society like North Korea in terms of what exactly are you talking about. And I think there are basically three or four things that I think we can note about such a society. The first is, of course, the lack of rule of law, and I think this was emphasized yesterday. And then, of course, you have the second aspect, that is the past and present human rights violations, massive violations of human rights, past and continuing human rights. And then, of course, you have the impunity that goes with the violations. And the fourth characteristic, I think, is the economic devastation and the decay. And I think this was also discussed yesterday in terms of the what prevails economically in terms of the But I think these societies also face a further challenge, and that is the articulation of a vision of a new society, to move from where they are to actually a new society. And I think that is a huge challenge for a situation like North Korea. And it means that we must look at the questions of governance structures, that can, actually enhance the protection of human rights and advance the protection of human rights. So it's not just a question of dealing with the violations, but how do you actually structure the society? How do you articulate this new vision? And what vision is it? I mean, what is it that you want to create out of this? And I think the other characteristic of these societies is a lack of national institutions and infrastructure to deal with the past and present human rights violations. I think we mustn't assume that there is actually institutions that can deal with that. I think in most of these places, that is one of the major problems, that the institutions to deal with the human rights violations, both present and past, are not there. So now, in terms of experiences internationally, I think that we can identify a number of approaches, and I think those, again, were identified yesterday, which is questions of prosecutions. That's one option. And this can be both at the domestic level and at the international level. Now, of course, when you talk about prosecutions at international level, then you're talking about, for example, the examples of the ICC, and then, of course, the special tribunals that have been in there, Yugoslavia, Sudan, Rwanda. You have the phenomenon of mixed tribunals, which is, Sierra Leone, Cambodia, Beirut, and others. And then, of course, the other forum is the domestic forum. And each of these has its own limitations and problems, and I think we have to be conscious of that. I mean, for example, the ICC has, of course, jurisdictional issues sometimes. In the context of whether the court would actually have jurisdiction over a state like that. And then, of course, there are problems in terms of the court itself having access to individuals that they want and that sort of thing. Because that, again, depends on the cooperation of states where these individuals are, assuming that some of these individuals are not in that given place. And the special tribunals, there is great resistance to establishing special tribunals, in terms of Yugoslavia and Rwanda. And I think you saw that in the context of Sudan, where the U.S. was more in favor of trying to establish a tribunal, and the others were saying, why should we? After all, now there is the ICC. So I think one has to contend with that. Now, the use of domestic courts, of course, again, has its own problem sometimes, in the sense that the level at which one is talking about prosecutions, in terms of perpetrators, you're talking about thousands of people, and this can crowd out any other business in the courts if you actually say that you're going to use domestic courts. And I think those were some of the considerations that were, for example, discussed in the context of South Africa, apart from the fact that there's a question of whether actually those courts were the appropriate courts to be dealing with that. And then, of course, there's the option of the truth commissions, and truth commissions, both reconciliation and reparations, can have all those elements together. And I think an important point that has to be made is that these tribunals are used also to really be a forum for reconciliation through justice, but also, as was mentioned, create a historical record. That in the end, you have a record of what happened, or at least, some reliable record where you can actually look and see what happened for the sake of posterity, as well as actually having a record of what was going on. And of course, there is the question of accountability, that you do hold people accountable through these processes. Now, I think one point that has to be made, that it's not an either-or. It's not like you go to truth commissions or courts. You can have both. And actually, lots of processes have both. The South African process is often seen as a truth commission only, and that's wrong. Actually, the South African process had both truth, it had reparations, it had also prosecutions. So you can have all elements in a structure that tries to address questions of past human rights violations. But I think it has to be emphasized that criminal prosecution at both domestic and international level need very strong institutions in order to carry out these processes. So one must not assume that it's that easy to simply say prosecution will happen. North Korea does not have the institutions that actually can, I think, carry out these kind of tasks. Now, this, of course, would mean that it will lead us to consider the question of rebuilding the domestic judicial system and supporting services, so that, in fact, you can actually use them if you are going to opt for domestic approach. Now, between the choice of an international system and a domestic system, there are advantages, there are disadvantages, and I would like here to refer to some of them. Some would argue that, local prosecutions are preferable to international prosecution for several reasons. International tribunals, because of the way they are structured, can never really deal with the thousands of cases. They will end up just dealing with the main cases. It's the structure of the course is very expensive. It's a lot of time involved. And also, international tribunals can be perceived as distant, in the eyes of the local people. And this is what you get in the context of, for example, Rwanda, where the tribunal was actually being held in Tanzania, and people in Rwanda are just wondering what's actually going on, and they read just like we read in the U.S. as to what actually is happening. And that, again, has its own costs in terms of the local population. And don't forget also that the international tribunals don't have coercive powers in terms of actually collecting witnesses from states. You're totally dependent on states to cooperate in terms of people you want. So in the context of North Korea, for example, you really have to depend a lot on the question of on the cooperation of China, for example, if in fact a lot of the perpetrators are in China. And you saw that in the context of East Timor. I worked in East Timor during the transition there. And one of the major problems in East Timor is not that East Timor didn't want to do anything or the UN didn't want to do anything in East Timor. The perpetrators in East Timor, Waranto and his friends, were in Indonesia. And you needed the cooperation of Indonesia if, in fact, you're going to have a process that was effective. And East Timor did not have power, to actually collect the individuals from Indonesia. So those are some of the problems that you face when you opt for an international system, that it is dependent on other states. It can only deal with a given number of perpetrators, and the preference is often, as we saw in Yugoslavia, but also in Rwanda, for taking them sort of the main actors in the conflict. Now, some also argue that local tribunals have an enduring positive effect in the local justice system, in that, in terms of norm articulation, but also building up the system that it can actually begin to be a system that deals with the both past but also current human rights violations. What I'm trying to say there is that a well-structured local system can actually strengthen and legitimize and in the long term actually train lots of people in dealing with the human rights violations. Now, in my paper, you see that I try to discuss this question of the courts and what can be done in some detail. Now, coming to the question of lessons learned from these processes, I think one of the major processes, one of the major lessons that I take from process that I've been involved in is that dealing with the past human rights violations must include transformation of the society. That is, the constitutional transformation, everything. Because don't forget that, in fact, the violations are going on because there are institutions that are involved, and those institutions cannot guarantee democracy or a new order unless they actually transform themselves into institutions that can support democracy. And that means reform with security systems. And you see that in the context of countries like South Africa, where sometimes the constitution is far ahead of the police, and Maracana incident and all that sort of thing. And you see that difficulty. So what I'm suggesting really is that as we're looking at the question of North Korea, one should also look at transformation in terms of articulating what kind of society you want to create and what institutions are necessary to create that. And that would also mean reform of courts, reform of security forces, reform of the civil service, and all the institutions of governance, really, so that what you have are institutions that can guarantee and underpin the existence of democracy. So the next point I think I gather from this is that I think a process of dealing with past human rights violations can only succeed if there is commitment at the highest level in terms of leadership, but also even in the context of the institutions themselves. I think a lot is talked about the South African process as a model, and I think I agree it is. And actually the South African process was borrowed from Argentina, and at a time when it was being discussed, I remember very well because I was there, and Borrell went to Argentina and was sent by the delegates to go and look at what was happening there, and then learn from there and improve on what they had seen there. So there is that aspect that you need the leadership. And I would argue that part of the reasons why the South African Truth Commission succeeded is people like Tutu. I mean, because they have legitimacy in terms of all groups, that no one could actually afford his judgment over things or accuse him of bias. And the leadership is critical in a lot of these institutions. And the leadership is much more critical in a developing state than in an established state like the United States, because the institutions can withstand bad people. But in a new society, an institution cannot withstand a bad person. And so don't just focus on having an institution, but focus on leadership too, because these are critical as you are trying to articulate these things. The other lesson is I think they need to manage expectations. And this is, difficult because you see, you can build up so much hope, in terms of actually what you can achieve and what, and sometimes it's beyond, sometimes it's not realistic. And then you can have a crisis, because the expectations that will solve everything, will know the whole truth, will know this, and then people get very disappointed. And I think you have to have, as you structure whatever is to be done, you have to look at that aspect, that, you really have to have a way in which you're going to manage these expectations that you're building up. And then thirdly, I think that the process of looking at past human rights violations must be holistic and must not be seen as just targeting North Korea. To me, that would be a mistake. I'm not here saying that South Korea has a lot of human rights violations, no. But it's just that I think that you have to package it in a way in which you are saying we're going to look at human rights. And I think, again, here an example is South Africa itself, that, as the discussions were going on, I think that for a long time, when the target was simply the apartheid government, it looked like actually the thing was going to be derailed. But the ANC came on board and said, no, we subject our camps to this inquiry. And they did, actually. I mean, and they knew, of course, that theirs was a legitimate cause and there wasn't really much that was fine, but still, it was subjected to the same process. And, of course, that created, you have to sort of diffuse the idea that, it's just us that they are after. And it's natural that people think like that, and you have to deal with that issue. So the other one, the other lesson I learned is that, yes, context matters. And we had this a lot yesterday. It's political, it's this and this. Yes, it is. But I also emphasize that context has minimum standards. And this is where the international instruments come in. I mean, there are minimum standards, what we've learned in the courts, what were the human rights instruments, and all those. We can't compromise on those. And it has to be that as a flaw. So that as we look at the context, we also do have standards that we are trying to to look at. And that's, of course, the courts, the various international instruments, and the other. Now, I mentioned the ICC. The problem, of course, with the ICC is that it is there, but remember also that it has complementary, jurisdiction. But of course, that will probably not be difficult to overcome. But then you also have jurisdictional issues in terms of which I refer to, and you also have problems with the expense and, of course, the time. It takes, with these international trials, it takes so long. Just consider the Kenyan situation. The indictments in Kenya were being discussed 2008. There's not even been an appearance up to now, isn't it? The first trial is supposed to be July 9, I think. But this is like almost 5 years later. You still try crafting indictment. And I think that's the thing that you have to deal with, that the international processes are very, very slow. And I think also the process must be owned by Koreans. This is very important. I think that, yes, you seek international support, and I think international community has a responsibility to support Korea in this process. But it has to be owned by Koreans. It must be their own. And even when you seek international support, you must support on your terms, and not that the international community should lead the process. Because it then gets really very complicated, because international communities don't come free of baggage. They have their own interests, including the United Nations. I mean, I think that you have to be careful, and they are necessary allies, but one has to be to make sure that the local people continue to be the owners. And then the other aspect I think that I would like to emphasize is that we have, as we try to look at past human rights violations, we have to focus on marginalized groups as well. Because you see, for example, if you look at the South African Truth Commission, despite its being a model and success, there's actually no mention of gender violence in that. You look at the report, nothing. Why? Because, it was not targeted as a topic in it. And I think that you must be careful to make sure that, in fact, you do research and try to bring issues of marginalized communities as a focus, and then they'll be dealt with. Otherwise, what you have is you have a model of South Africa with its Truth Commission, not a single mention of gender violence. And yet we all know that a lot of the violence was, in fact, gender-based. So I would say that one has to look at that as well. And then, of course, the time. That you don't want this process to be forever. Then, it kind of really dilapidates the state. I think there's need to, first of all, determine how far you go back, but also how long this process is going to take. And that in itself is also a question of management, and I think it's important that that is done. And I think just to emphasize, my last point would be to simply emphasize the point that this has to be a process driven by Koreans, and the international actors should, can help, but don't consider them to be without baggage. And I think that it is, if you make mistakes, they must be Korean mistakes, and not mistakes of other people. Thank you very much.
Okay, thank you very much. Professor Ruti, microphone.
Thanks. So I just want to pursue in my remarks the framework that I proposed yesterday, which is that we're in a global framework for transitional justice and what that might mean for unified Korea. And that is talking about, first, an idea of transitional justice that is not limited to the transition. So ex ante, the role of international law, I'm going to say something about that, diverse actors, and then lastly, the fact that when you have this kind of steady state approach to transitional justice, clearly it's going to be complex. There are a variety of different stakeholders, and this isn't linear. And I take some of the interest that we've heard over the last day from Asan as an NGO but also involving other states as an instance of a stakeholder that has a particular interest, a distinct interest in transitional justice that may well be different from that of other actors such as the UN or North Korea in a successor regime. So just some thoughts on how this could play out. So 3 places where international law is playing a role now, ex ante, before transition, intra-conflict, and then in the post-transition period. So ex ante, what we've heard about so far is that the very exciting development of the UN appointing a body to examine human rights violations in North Korea. And this is a very big step. This UN probe that has been announced this month is along the lines analogous to UN probes that occurred with regard to the human rights atrocities in Kosovo, and later leading to a tribunal, ICTY, and also UN probes with respect to Syria. So just reflecting back on the International Criminal Tribunal for the former Yugoslavia, and there was an expert commission that was set up in the early 1990s after revelations by reporters of the terrible torture and detention that was going on in the Omarska camp in Bosnia-Herzegovina. And at that time, the UN Security Council set up under its charter and Chapter 7 powers that are committed to peace and restoration of peace, they set up a special ad hoc tribunal. So there are these analogous, there are these prior models. Obviously, the situation in the Koreas is different. This is not saying that these are on all fours, but given North Korean aggression of the recent month, involvement of Security Council obviously is not inconceivable in bringing together the issues of war crimes, potential war crimes and past war crimes, with the issues that victims and others are interested in involving crimes against humanity. So this UN rights body that is launching this long-awaited inquiry into decades of abuse. We heard yesterday from SKP from the camp, really extraordinary level of abuses, crimes against humanity for sure. This is something that Human Rights Watch, Amnesty International have been reporting on, but it has not been front-page news. It has not been something that has been subject to the kind of inquiry that we're talking about, and it will make a difference. So this Council resolution, which condemns these human rights violations, as I mentioned, including torture. So this suggests that the other third parties would really be under an obligation under the Torture Victim Protection Act and under the Torture Convention to prosecute. So there are third parties already involved once you understand the level of human rights abuses. If we're talking about torture, we're talking about something that is jus cogens and involves obligations by third parties. Now, what the response will be by the leadership in North Korea, obviously that's a question mark. There has been, as mentioned, significant support by the UN, including the top UN High Commissioner for Human Rights, Nabi Pillai, all supporting this and suggesting that it is overdue. Now, this, and there are many areas, including what we heard about yesterday, not only persecution and torture, but violations of the right to food. And that's, this is obviously a very important violation because it transcends the ideas of political violations of human rights. This goes to human security, which is a top issue right now at the UN and in Europe. And so the victims of human rights abuses in North Korea are really going to get significant support for their position once this report is issued. There are, of course, also foreign nationals involved. There are detentions and disappearances. North Korea has abducted foreign nationals, so from South Korea and Japan. And this makes it a regional issue, and I want to get back to that because obviously, we're talking about international actors, but yesterday we heard the significance of China and I want to say Japan on these issues, and it will be important to see their response. They, certainly Japan has been pushing for this investigation, and that will be critical. China obviously is affected. There are refugees. There are border issues. So this commission, which is really a first step towards ensuring international accountability for crimes against humanity in North Korea, will have regional implications. Now, this another related step that has occurred already is the referral of these issues to the International Criminal Court, and that is that South Korea is a signatory, and we have some examples where the UN, even where there were non-signatories, has gotten involved, such as the Sudan case involving Bashir, and in the case of Libya. And so there's a question of what role could be played by the ICC, the International Criminal Court, in their probe of alleged North Korean war crimes. Now, the focus of that is war crimes more than the crimes against humanity, although with the functioning, once this UN investigation and probe gets going, I would imagine that this will also affect the jurisdiction, as has been mentioned earlier, of the ICC. But in 2010, South Korea brought to the ICC and asked for a preliminary investigation into war crimes when there had been civilian shelling in South Korea and the sinking of a South Korean warship. And this was undertaken by the then prosecutor Luis Moreno Ocampo from Argentina, who had been involved as deputy prosecutor in the time of the trial of the junta. He was then, many years later, made chief prosecutor at the ICC. So this is a probe that's, this is an investigation that's also going on, and obviously South Korea. Republic of Korea has implementing legislation. They've made a commitment to the ICC, and so that's also an interesting development. What could the role of the International Criminal Court be? As Professor Ndulo mentioned earlier, obviously there are limits. The leadership in North Korea, is not, readily amenable to being taken, to The Hague, and so on. But we might think of the ICC as involving kind of presenting a shadow of the law, of a significant international law on war crimes and on crimes against humanity, and that once these two investigations, certainly the human rights probe, and then this investigation that has been more kind of under the radar of the ICC. This changes the discourse, right? Once you're talking about clear violations of international law, Secretary Clinton at the time hosted South Korean ministers from South Korea, foreign ministers from South Korea and Japan, and really trying to get support for putting limits on this kind of aggressive behavior. Now, what's interesting here is the ICC is really, the statute of the ICC is the first time that you have aggression back in the picture, war crimes and crimes against humanity, since Nuremberg. And so, we're in an interesting moment because this is an actor that is involved in kind of all sides of the concerns, right? Engaging in certain aggressive behavior on an interstate basis, but also attacking their own citizens and also attacking foreign nationals. So that's all happening. Probably the best use of some of these developments, these investigations, is that it contributes to a normative discourse of delegitimating the leadership. I can't emphasize more than was mentioned by Andrew Natsios yesterday, the significance of China, and I think once this kind of delegitimation continues and an absence of rule of law, and the rule of law language is very significant to China, then one might see more distancing and kind of more regional cooperation there. Japan also has is involved because of its failure of accountability, past failure of historical accountability, and so it too can show support for these issues, and so one might imagine regional developments on these issues, both of human rights and and war crimes. Now, there are dangers, obviously, and we heard about some of these yesterday. What could the response be of the North Korean leadership if there's a more coercive use of international law? There are scholars that are, concerned that, on the one hand, the best case scenario would be that a probe could lead to a shutting down of the Gulag and a release of some of, of the prisoners. Would that be a response to a mere UN inquiry? That's, question mark. I leave that to scholars of the state that have more information. But then there are others who think this could really blow up and lead to possible destruction of the Gulag and killing, executions, and an attempt to eliminate evidence, kind of like what the Germans did at Treblinka on their way out. And so that's, this is a real issue. Leading human rights lawyers are still pushing for the probe, but I think that all of these questions should be on the table, and that one shouldn't just endorse the use of international law or the ICC as a stick, but rather using it, turning to it in a productive way. And this is something that the former chief prosecutor has been talking about: the use of the ICC as a threat, as a form of deterrence, as a form, something that can add to judicial diplomacy, and not necessarily as only a coercive institution that was brought in later to put the leadership on trial. Now, so again, we don't know really right now what the effect of an ICC intervention into North Korea would be, and we don't know what the effect of the UN probe will be. But it would be important to get some buy-in by China, by Russia on these issues. I think an interesting question is what happened in Burma with respect to Burma. Obviously, China's role was significant there, and Japan also. Japan is a big aid donor to Burma, and we saw a very interesting opening with respect to Burma, and that's another issue here: is what role ASEAN played in Burma, and what role did some of the human rights accountability issues play, the U.S. stepping aside from a certain use of sanctions. All of these involve international players with respect to human rights. Now, moving right along, time is short, intra-conflict, the occupation trials, if we're talking about possible military intervention. Again, I don't know what the game plan is, but assuming that it's not about collapse, then we're talking about some kind of military intervention. And there, the examples, I know that you'll hear later comparative presentation by professors from Germany about the role of vetting in post-Cold War Germany, and also the excesses. We also saw that in Iraq, intra-conflict, Iraq, de-Baathification, terrible results, insecurity, and so on. So those are all questions that have to be thought about. What are the substantive commitments? I don't think we should, just talk about international law as a tool without really thinking about what are the substantive commitments here. What is the political project? How does one imagine? I mean, it's not clear to me that there even is in this room a commitment to unified Korea, as opposed to possibly some change of regime and having, two Koreas or some other kind of regional framework that involves peoples. There are a lot of different questions on the table, and I think that the issue of the role of international actors, okay, for sure, we know that the victims need to be repaired, and I want to come back to that, and that, concern about international aggression and war crimes. Now, lastly, ex post. Do I have a couple of minutes? Just a couple of minutes? 1 minute? Okay, I can talk fast. New Yorker, yeah. Ex post, the role of transitional justice after the regime collapse. And I think here we can think about trials in post-unified Germany. Problematic. Often it, ended up being small fry. The guards at the border, didn't particularly help reconciliation. Again, I think one has to think about what is the substantive substantive commitment. If the commitment is more reconciliatory, the conciliatory one as opposed to retributive, that's a different approach. Now, what I think is interesting is that today there's been a resolution of the civil war in Nepal and a TRC set up. And, it's kind of in more or less in some consideration of what the region is, and you have UN involvement there in supervising the current agreement and challenging the Nepali agreement to provide for amnesties in light of their TRC. So those are two sides of the picture. On the one hand, the dangers of some kind of mass retributive project, and on the other, how much commitment is there? Is there really a meta constraint here about prosecution, some kind of abstract commitment to accountability that doesn't allow a political space for amnesties? Now, I don't think it's at that point. I think there's still, there probably is a significant law now against blanket amnesties, certainly against politicized amnesties. If the leadership wrote their own amnesty on their way out the door, that would be off the table. But there are still, certainly, international humanitarian law contemplates amnesties at the end of civil wars, and so we might think about what the important, reconciliation goals would be. And I think for sure, and I just want to end on this note, the significance of repairing victims and what substantive commitments will be made to not just, what seemed to be, we heard yesterday, the numbers on the political, the current state of play in the society in South Korea as to, what they're willing to sacrifice. This involves leadership, right? For if there were to be a unified Korea, there would have to be a sense of equality of citizenship, of a willingness to take in and have all kinds of benefits that would allow those that had been politically persecuted, but also maybe the majority that aren't at that level to have a sense of equal citizenship. This was a real issue in unified Germany, and I think that one would need political leadership. From what I saw of the numbers, I don't think big data should drive the politics to that extent. That's a kind of status quo. It's not a transformative. That's not transformative data. That's where things are today. And if we're talking about transformation internationally and in North Korea, then obviously, in order for there to be a unified Korea, there would have to be change in the society. And courts can only be out ahead of society to some degree for their intervention to be legitimate. So there has to be a sense of buy-in. Obviously, as was mentioned before, this has to be from the region and from the state. So let me end there.
Okay, thank you very much. And next, yes, Professor Reiter. He is going to talk about the external actors and transitional justice in a reunified Korea.
Great. Thank you. Okay. So I will use PowerPoint. Hopefully you can see that on both sides. I'm the political scientist on the panel. I'll try to stand up for my discipline. My previous research on transitional justice is based in part on a large global database of over 800 transitional justice mechanisms used over 4 decades in over 150 countries. And so that's my background, is trying to uncover these patterns and what has already happened in the world with the goal of trying to predict what will happen in the future. Political scientists are not often the best at predicting what happens in the future, but we try. That's our goal, is to draw lessons from the past to think about questions like this. So we know, first of all, that the idea of a successor regime deciding what to do about the past regime is pretty much dead. That's not how it works anymore. There are tons and tons of people who are involved in that process. And increasingly, they're international actors. This is not simply a domestic decision anymore. Decisions about transitional justice are complex and involve lots of international players. But the big question is, why the variation? We know in some cases that domestic actors maybe are influenced a little bit by international actors. And in other cases, international actors pretty much decide everything. They often take over and run mechanisms themselves. All right, so what explains this variation? So it leads to kind of my big 3 questions. First, what types of international actors are involved in these decisions? I think that's a first step we need to think about. Who are we talking about? We've heard them mentioned anecdotally, I think, over the last a couple days, but I'll try to categorize them a little bit so we can get a grasp on the various types. And what explains the variation? Again, I think that's the key question, is why are some states influenced more than others? And then, of course, building off of that, what lessons could we learn for a unified Korea, given the caveat that we don't quite know how that transition would of course, play out. So I'll take you through three categories of external influence. This is my first attempt at sort of categorizing these. So this is a work in progress, but I think of this when I look at cases as there being indirect pressure and some sort of moderate pressure, which often comes in the form of funding and support for particular mechanisms, and then very, very direct pressure, where external actors are influencing domestic actors considerably to influence their transitional justice decisions. So when I talk about indirect pressure, we're thinking here about international norms, right? Transnational advocacy networks, human rights organizations that work together to push for particular types of behavior. We know that some states are more or less susceptible to those types of norms than others. It's very indirect. It can't influence a decision directly, but certainly states that are more tied into those types of networks are more likely to adopt those types of behavior. International treaties, international law, again, often very little enforcement mechanisms on lots of these treaties, but I think scholars and law scholars in particular have shown that they do have some effect, often indirect, at pressuring states to behave in particular ways. International court rulings. Inter-American courts probably the best example of this, of making various rulings in Latin America that have then had strong domestic impact. But in other cases, for instance, Brazil, it's not had much of an impact because there's lots of variation in how courts can influence particular countries. Some can resist those pressures, others can't. So it's often, again, very indirect. You have to sort of be shamed into changing your behavior based on a court ruling. And then similarly, regional histories and experience, it's very indirect, but if there's been something in the region in which a mechanism has failed very badly, then you may see a country not wanting to take that particular path. Similarly, if other countries in the region are all doing something and it's all working, then we would see there might be pressure for a country to adopt that same type of approach. We're looking at moderate pressure. These are just some examples I threw up here. There's plenty more. We often think of transitional justice, I think, as trials or truth commissions or amnesties, but really it includes a lot these days. Things like rewriting constitutions, reforming the security sector, training judges. I mean, these are all things that are often under the rubric of transitional justice, and they often involve lots of international actors who give advice and funding for these programs. Even thinking about forensic and investigative services, most countries don't have people trained to exhume bodies and do DNA testing. I mean, those are very, those are jobs that need lots of expertise, and they often come from international actors who come from abroad and help with those types of programs. Similarly, just aid and outreach to victims. Oftentimes, international actors like the UN, right, World Food Program, we've heard those already mentioned, do a lot of work on the ground to reach victims, organize refugee camps, provide them services, provide outreach to those victims when the state needs to reach into that community. And also thinking about the last point here, direct transitional justice advising. It's almost what we're doing today, trying to come up with policy prescriptions, advice for countries. And many organizations, for instance, International Center for Transitional Justice, that's their job. They go to countries and contract with them and work with them and try to advise them on what to do. Right? Other places like Amnesty International maybe write reports and give some advice as well to countries to tell them what might be best for them. We see lots of organizations around the world doing this on a regular basis. And then thinking about direct pressure. These are the ones that, when you think of external influence on transitional justice, you probably think of. This is the United Nations running a tribunal, right? Thinking that's the direct operation of mechanisms. International actors actually take over or run or work and do sort of a hybrid mechanism with the state. The first part I put up here, negotiation of peace agreements with transitional justice components, we often think of conflicts ending and regimes transitioning. That often involves international actors playing a role in the negotiation process. And at times, they may insist or help or organize a particular transitional justice aspect to that. Most recently in the news, we can think of Yemen, right? Salah's removal from power was granted an amnesty. Not surprising that the Gulf Cooperation Council did that. Those are 6 monarchs who have kind of a vested interest in ensuring amnesties in the region. But that was part of the deal, part of the negotiation process, is they put that in there. And now it's be very difficult for Yemen to then oppose that type of process that's already been negotiated by international actors. And then when we think of the last point here, refusing to cooperate or using leverage to insist on particular responses, we've already mentioned Indonesia just simply refused to give the perpetrators to the court. A very easy way to block transitional justice, block justice in that case. Ben Ali from Tunisia is safe in Saudi Arabia right now. Right? We think of Noriega from Panama. Panama did not finally get to put him in prison in its own country until 2011 because the United States said his drug convictions and money laundering is most important to us, and he's going to go to jail in the United States. Right? Essentially blocking Panama from being able to really deal with its own past for 2 decades. Right? So we see this a lot where countries intervene and essentially prevent the state from actually dealing with the past the way it wants to. So why the variation around the world in these external influence? Openness of society. Some countries are more democratic, more open. They're therefore more susceptible to international NGOs working in the country. Some countries are more closed, and that's not as big of an issue. Integration in the international system, same idea there. Have you signed treaties? Right? Some countries have, some countries haven't. Political and military power. I use the Brazil example again, able to sort of resist the pressures from the Inter-American Court because it's a strong regional hegemon and is able to do that, whereas other countries like Guatemala maybe are not as able to do that. Right? And economic development. Some countries need a lot of international assistance because they're very poor and they can't handle all these services themselves. More developed countries maybe can, right? They're not as reliant on international aid and actors. And then finally, regional dynamics, which I think comes up clearly in the Korean case. Particular actors may have a very vested interest if it's a key state that maybe is important to international players. Right. So transitioning now to application to a unified Korea, thinking about indirect pressure, I think we would say this is going to probably be very high in a unified Korea. South Korea is a long-standing democracy. It's very well integrated into the international community. It has a strong civil society. It signed all the major treaties. There's going to be a lot of international actors who are going to want to influence and be able to influence, right? They'll be able to mobilize. They'll be able to organize. You'll see victims groups mobilize. You'll see lots of international NGOs having a say, I think, in this case. All right. Moderate, thinking about funding and support. This is interesting because this case, because it's 2 countries we'd be thinking about in a unified question, we're looking at North Korea directly, we would say, well, of course, international influence is going to be very, very high because North Korea is very poor and underdeveloped and is going to need lots of assistance. Whereas if we looked at just South Korea, we'd say it's a very well-developed, economically stable country that maybe needs less assistance. So it's going to be somewhere in the middle, but I would say that there's going to be definitely some influence here. We've mentioned already the panel yesterday that this could be one of the worst humanitarian catastrophes ever, so South Korea would not be able to handle that on its own. Right? It's going to need international help to do that. But it'll be more able to resist some international pressure than other states, I think, because it's going to have some ability to take over some of those services itself and maybe pick and choose more of which international actors it wants to get involved. And then in just thinking about, we've already mentioned collecting data on human rights violations. I think one of the comments yesterday was there's a lot of people doing it but not really coordinated yet. And I think that's endemic of what's likely to continue is you have lots of actors doing lots of things. There's going to be lots of voices in the conversation, essentially. They may not always be unified, and they may be conflicting. And I think there's going to be lots of people involved in that process. And again, this conference is a perfect example where we're part of this process. And there'll be other conferences like this. There'll be other think tanks working on the same issue. And if this takes 10, 15, 20 years to happen, there's going to be more and more people who have a very strong view of what should happen, and they're going to let their voice be heard during that time. And then thinking about direct pressure, this obviously depends on how the transition would take place. But you're going to see the United States want certain things to happen. You will see China want certain things to happen, and you may see other actors, for instance, Japan, as we mentioned, or the United Nations, if it's involved, want particular responses to happen. If the United Nations or major international powers have to have troops on the ground, they're probably going to insist on a particular type of transitional justice response, probably justice for those, right, who have committed violations. And so it really kind of depends on how much international involvement at that point. China, I think we can just say no matter what, it's going to oppose particular types of responses. We've already mentioned the Indonesian case as an example. I would think, again, very hard to predict, but it wouldn't surprise me at all if perpetrators flee to China and China refuses to release them, and if China also tries to smuggle out evidence over the border to make sure it's not confiscated by other actors. Right? Those seem very, very likely scenarios to me in that case. So the conclusion: international assistance is going to be important because this is going to be a really, really difficult case. Lots of violations, lots of abuses to investigate, lots of reconstruction to do. International assistance will be important. And maintaining key allies will be important. A unified Korea is not going to want to alienate the United States. It's not going to want to really anger China. It's not going to want to create new tensions with Japan. It has to balance all of these big questions. But at the same sense, we've talked about already through this conference that local ownership is important and that they need to feel like it's their process. And so it's going to be a series of challenging trade-offs, I think. I think there's going to be lots and lots of voices involved in this. And very difficult decisions about how much international influence to allow, essentially, in that process. Right. Thank you.
Okay, thank you very much. Thank you very much, distinguished three panelists. And this is the time I have to change my role into speaker. I want to talk about the United Nations as a potential international actor in bringing transitional justice to the Korean Peninsula. If you look into the history of the divided Korean Peninsula, the United Nations intervention will be inevitable when the time of reunification arrives. Before I get to the point, I think I should clarify one point which seems to me very significant for our further discussion of transitional justice in terms of systematic, widespread, and grave violations of human rights in North Korea. Yesterday, Dr. Bong, explaining to you South Korean public's perception on transitional justice, included international humanitarian law violations by North Korea, such as the sinking of Chang-Hoon vessel and the shelling of Yeonpyeong Islands, in the scope of our discussion on transitional justice. In addition, yesterday in Session 2, we discussed human rights violations in North Korea, but no one explained why the violations should be dealt with in the context of transitional justice. As a result, well, some might, especially from the audience, might have been embarrassed coming to the conclusion that the violations were not committed in time of conflict before reunification of both Koreas. There was no sufficient explanation on the linkage between human rights violations and transitional justice in post-unification Korea. The embarrassment partly comes from, generally speaking, investigations and prosecutions for human rights and international humanitarian law violations committed during conflict would only be dealt with under transitional justice mechanism. Therefore, the scholars and practitioners also in transitional justice here in this room might have been wondering what would be the scope of transitional justice, particularly time scope, when dealing with transitional justice after reunification of Korea. Accordingly, it is natural that some have argued that there must be an assumption that there will be a certain time span, period of conflict before the reunification. However, there is an important fact which constitutes a meaningful legal background with regard to the time span of the conflict. if we consider this fact as constituting a meaningful legal background, you may clearly understand why all the violations of human rights so far and international humanitarian law violations so far, particularly posed to the questionnaire of the poor conducted by the Asan Institute, and why we are talking about the current violations of human rights in North Korea, dealing with the issue of transitional justice. I mean, you may find linking points between human rights violations and transitional justice. The very fact is that both Koreas are still technically in war. Both Koreas are still technically in war, so that we don't need any kind of assumptions, as some argue. In order to end the Korean War, the armistice was concluded on 27 July 1953 by the U.S. Army representing the United Nations Command on one side, and the North Korean People's Army and the Chinese People's Volunteer Army on the other side. From this fact, you will also recognize why the United Nations should be involved in bringing transitional justice after reunification of both Koreas. The armistice was concluded in order to ensure a complete cessation of hostilities and of all acts of armed force in Korea until a final peaceful settlement is achieved. 60 years have already passed since the conclusion of the armistice. Nonetheless, no final peaceful settlement has been achieved yet. The armistice established the Korean demilitarized zone, and the zone runs not far from the 38th parallel, which separated both Koreas before the war. Interestingly, North Korea has announced that the armistice was null and void at least 6 times so far. This clearly indicated that we will be still in transitional period, and this indication has been supported by the fact that North Korea has argued so whenever it declared the armistice was nullified. If I tell you other interesting events which may be addressed in the context of transitional justice, they are, well, as I already mentioned, sinking of the South Korean Navy vessel Cheonan and the shelling of Yeonpyeong Islands, which led to the casualties of civilians. However, since the cases are under preliminary investigation of the International Criminal Court, their justice will be dependent upon the result of the preliminary investigation. And this is the very example of the International Criminal Court as an international actor is engaging the past with regard to Korean Peninsula, with regard to the transitional justice in the Korean Peninsula. Anyway, given the facts I mentioned, one may argue that the whole 60 years, if we achieve reunification today, will be the past that should be addressed in the process of transitional justice. As another interesting fact, we may raise the issue of prisoner of war. The armistice stipulated the arrangements relating to prisoners of war. Nevertheless, the South Korean prisoners of war have not been returned to South Korea. In practice, because of the lapse of time, it would be difficult to achieve criminal justice. I mean, to maintain indictment against North Korean government. If so, the room for international actors' intervention will be limited in case of, in criminal justice as well as civil justice. Yesterday in session 2, some panelists mentioned the implication of the COI, Commission of Inquiry, which has been established by the United Nations Human Rights Council, with regard to the deterrent or preventive impact on human rights violations in North Korea. And in opening remark, I said that the COI's report will be conducive to raising the public awareness on the situation, on the current situation of human rights in North Korea. And Professor Teitel also pointed out the significant implications of the COI. In addition, I want to point out one thing more, that the COI's report will be conducive to the accumulation of documentary evidence to redress the violations and will be the starting point of the investigation to achieve transitional justice after reunification of Korea. This type of intervention from the United Nations may be more intense and even will be expected by both Koreas after reunification. I presume, though I agree with Professor Ndulo on the point that local people, Ndulo as well as Professor Reiter, that local people should be the owner of the transitional justice process. To explain this, I want to start with some provisions of the constitutional law of the Republic of Korea. Article 3 of the Constitution of the Republic of Korea stipulates that the territory of the Republic of Korea shall constitute of the Korean Peninsula and its adjacent islands. Therefore, North Korea is just rebellions or belligerent group in accordance with domestic law. However, interestingly, Article 4 stipulates the Republic of Korea shall seek unification and shall formulate and carry out a policy of peaceful unification based on the principles of freedom and democracy. There might be different interpretation with regard to these two provisions because they are conflicting with each other. On the one hand, North Korea is just rebellion or belligerent groups, but on the other hand, North Korea is a partner that we have to achieve the peaceful unifications. So it's contradictory provisions. However, I think, for example, one may argue that the provision is not realistic because the only scenario of the peaceful unification based on the principles of freedom and democracy will be the surrender or absorption of the Kim's regime to South Korea. As a policy researcher, however, I think I should be more realistic. Since the United Nations command, represented by the U.S. Army, is one party side of the armistice, the intervention of the UN will be inevitable in the negotiation of peaceful unification. In addition, even if the United Nations allows both Koreas as sovereign states to deal with their peaceful unification on their own, as Professor Ndulo emphasized, in the process of transitional justice, nonetheless, the UN will play a very significant role. So, as a conclusion of my remarks, I dare to say it will be a realistic prospect that both Koreas may not want to monopolize the process. If considering, it would be a very tragic story, but if considering the trade-offs between peace and justice. So they will toss the burden of the criticism on the trade-off between peace and justice to international actors such as United Nations Human Rights Commission or other international tribunals. Particularly with regard to international tribunals, only the head of states or the high-ranked officers will be indicted. So this could explain the overall picture of the transitional process and the reunified Korea. Thank you very much. And then, yes, moving back to the moderators, I'll open the floor to, okay, yes. Yes, please.
Mike Massetti, obviously the United States is a key player in Korea in a way that it far more was in Yugoslavia, and certainly far more was in Rwanda. But the United States is not a participant in the ICC. There's been a lot of discussion about the ICC here. To what extent might that be a complicating factor?
I can say something. You can too. So, just real quickly, and others may have their own view on it. My sense is that even though the U.S. hasn't officially, we had signed, and then there was the unsigning, right? If you remember the transition between Clinton and the Bush administration. But since we're not signatories, that's true. We're not officially part of the treaty. On the other hand, we've certainly gone out of our way, I think, over the last, and this started with the Bush administration, to cooperate with the ICC and to refer cases to the ICC. So Sudan Bashir, that was under the Bush administration, and the remarkable alacrity with which the referral in the Libya case occurred with full U.S. support is another example. So I don't think anything stands in the way. I don't think that legal question of the connection between the U.S. And the treaty regime is the issue. As I see it, I think there will be political considerations about whether this is a good idea, whether it's seen as coercive, and so on. But I think that it's the same way that one thinks about Syria. Would it be a good idea to have more international institutional involvement? I think the real question there is political, and not the question of formal membership in the treaty. There are a lot of examples of cooperation.
Yeah. Professor Ndulo?
Yeah, just to support that view and just give further instances of actually U.S. cooperation with the ICC. The Kenyan process, the U.S. is at the forefront of actually insisting that the trials must go on. But recently we even had the experience of the U.S. actually taking a perpetrator to The Hague, the Congo incident. They're the ones who actually transported the person from Rwanda to the ICC. And so there are many examples that they're really cooperating, and the Kenyan, Bashir and all that, yeah.
Okay, I'll take two questions, and then yes. And that after.
Thank you to everyone. So, big learning experience. Kathy Moon from Wellesley College, also political science. These questions are for any of you, because I'm trying to integrate some of the thoughts you've offered, observations you've offered. And it relates also to Dr. Shin's final comments about the contradictory and conflicting nature written into the Constitution, but also I wanted to talk about the contradictory, conflicting nature of South Korean democracy. One, Professor Ndulo, you mentioned, you seem to assume that the transitional justice issues that would arise and the kind of warning signs you give us, things to look out for, things to avoid, things to include, that the assumption is that we would be pursuing transitional democracy in a democracy, transitional justice in a Korean democracy. And my question is, what if we have some kind of a form of unification, or forced or imposed unification, or surprise unification, let's say through migration crisis, or a coup, or collapse in North Korea, where you don't have a democratic system that can incorporate North Korea established. I do research on this, and this is one of my greatest, not fears, but concerns. What will happen to South Korean democracy when you have an influx of North Koreans who are not trained properly, normatively or institutionally, in democracy? So that's one. How might we consider other political arrangements in which transitional justice can still be pursued while democracy is in transition in Korea, on the peninsula? And two is that related, Professor Reiter mentioned Korea as a long-established democracy. It is really not a the start. It's a young democracy still, and it's a vibrant democracy partly because it's like the wild, wild west. I mean, people are still going at, punching one another out to fight for a piece of the civil society, fight for political participation and inclusion. And my concern is, and then Professor Ndulo also mentioned to focus on North Korea not as a target, but a context of other nations or actors that should also be brought into the transitional justice process. My concern is that in South Korea, given the way South Korean politics works, that it would be very hard to streamline a political process, to coordinate and concentrate different grievances through one system. And I can easily foresee North Koreans, for example, or Northern Koreans who, in a unified Korea, suing the South Korean government, the Japanese for colonial, nobody's touched this, but the colonial legacy of Japan is going to be big in a reunified Korea, probably bigger than it is now in some ways, because North Korea never got to make the claims. It didn't have a 1965 normalization treaty. And then you have South Koreans who will seek out property rights in North Korea and vice versa, which they're already doing, the North Koreans defectors. So I consider this a very messy process. And so I'd like you all to address some of the messiness and what to do in that circumstance, and if there are precedents where you try to coordinate interests better, especially given the sort of vibrancy or wildness, you could put it, of South Korean democracy and the lack of democracy in North Korea.
Lavinia.
So
We'll take one more next one. Questions?
I just have a question about to any of you, whether you thought about the impact of the ideological factor in allowing crimes of communists to be heard, to be prosecuted through international courts, because that would be for the first time in history. And I remember in the 1990s when the Western Europeans ganged up against Eastern Europeans, raising the flag of, don't do this, don't make sure that post-communist transitional justice doesn't look like revenge, make sure that trials of communists do not amount to a trial of communism as an ideology, So, and I don't think that the international mood towards putting on trial crimes of communism has changed significantly during the last 20 years. Actually, in 2009, I was part of a European Commission report trying to address or to study some of the crimes of communism in Eastern Europe. And Mr. Barroso, in the end, said, no, we cannot go here, no more funding for this project because the European Parliament is so divided, the socialists are so, they don't want to hear about this, don't go there, don't. So I would like to hear from you what you think about this.
Okay.
We'll go first.
Okay. Yeah, I think both excellent points brought out, and I think the part about the prosecuting communism as such, I think it's I agree entirely with you that I don't think the mood has changed, and I think that's why then we need to emphasize on the norms, in terms of the human rights norms that we are actually targeting, so that it becomes what you are punishing are greed violations, in terms of what the courts have dealt with, literature from the ICC, from Yugoslav Tribunal, and also the various norms, the war crimes and that kind of things. And I think it's very important to frame the debate in that context rather than in ideological terms, because I think then you can have always have a problem. Now, on the question of the democracy, I think that, you're absolutely right. And I think that my point is that you have to see transitional justice as including transformation, Because for me, unless you do that, you're going to have a problem. I think just this morning at breakfast I was discussing with Professor Stan that, look at Romania, what had happened. They thought actually, they had moved so fast. And 25 years later, the communists take over again and everything is reversed. Because, in fact, there really hasn't been transformation, in the sense that the institutions that are supposed to anchor this new society of human rights are not there. And then you face this total reversal, and I think that's what it points to, that it's not enough to just deal with the human rights violation, but also, as Tutu says, it's like you cross the bridge, to a new society. That how do you cross this bridge, and what does it take? And I think the Asan Institute has a challenge to discuss this kind of issues. That what is it that's going to take to cross the bridge, to this new society where rights will be respected, and then you really are having a new debate.
So, just picking up on that point first, I think of the Middle East now and countries, Libya, Tunisia, Egypt. They're not in full democracy mode, and they are dealing with issues of accountability, and it is complex. It is complex. In general, what they have, Tunisia probably is the farthest along in having democratic, legislation. Still, tremendous debates, but one could imagine in some of the other regimes, and we're seeing it, a consultative. They will have consultative regimes. There will be more or less role for religion in some of the, we're talking about liberalization. We're not talking about democracy overnight. That's why, in the early 1990s, I was using the term transition instead of revolution, right? Hannah Arendt imagined the founders in the U.S. and having a constitution after a revolution. But people who study American history know that wasn't the case. That, there were the colonies, Articles of Confederation, even, a democracy that can boast of a long-standing constitution. It took some time, and you had a bloody civil war that was not, there were issues that were put off. The terrible, the difficulty of the slavery and race issues were put off until another day. And of course, that's not, that kind of 100 years postponement is not, people, today that's not possible because we have globalization, we have, interdependence and without political integration. So I think that, they're dealing with those issues for better and for worse. Accountability is not the same as democracy. They want some sense of rule of law. Rule of law is not the same as democracy. So I think that, we're going to need to develop a vocabulary here that is going to be sensitive and nuanced, and that where there isn't, we'll be aware of what is being contributed. A historical record is not the same, right, as having liberal trials and fair. And I think that if you can't have trials that are in keeping with the rule of law, then there shouldn't be trials because it won't convey that sense of a change. And I think that's something that needs to be discussed here. Is that what is the project, and if there's going to be a sense that this is a different moment and something that people can feel that where there's equality of citizenship, there has to be due process and the same applicability of law with respect to prosecutions of serious crimes. So that's where you were saying maybe better to go to The Hague and have some very limited trials that's there if this can't be guaranteed locally for that period of time. On the other front, on the interesting question that Lavinia raised, I think that what we're talking about are crimes of persecution, political persecution. So it's not really whether communism is on trial, but my view is that crimes against humanity provides for that it is an offense to have systemic political persecution. Genocide doesn't have politics in it because the Soviets were so involved in that treaty, in the convention, because it was a Cold War convention. But the normativity of crimes against humanity under the Rome Statute and the way it's evolved includes political persecution. And so, where there's been such persecution, that statement needs to be sent, and that will it delegitimates what might otherwise there might be some positives, and I think this is going to happen with respect to the transition in Cuba as well. That's really about the normative constraints here are is persecution in the name of ideology. So,
Great. Yeah, I'll add just a couple things. So first, long-standing democracy. I actually thought twice about putting that up there. Of course, length of democracy is a relative term. and when I'm thinking of transitional justice, certainly you'd have to agree that South Korea has a leg up on countries in the Middle East who have never had an election, don't have real constitutions, don't have working courts, right? So that was sort of my implication of that. It has some sort of foundation in which it can build on. It has some sort of civil society. It has rule of law that it can draw from in doing this. But I take your point, right, that it's still growing pains, right, with all democracies. And going back to Ruti's point on that. And thinking about how to deal with this, I mean, I agree completely with you that it's going to be a mess and it's going to be a huge challenge. I would just say that in looking at other countries, it's not uncommon to put significant restrictions on what we'll deal with at particular times. Countries often say, this is off the table, we don't have the capacity to do this. But then what we often see is that those things get revisited over the decades, right? So, I mean, this is going to be a 30, 40-year process. I think you're going to see certain sets of crimes that they'll be saying, we're not going to do property rights. It's too complicated. But then over 20, 30 years, after other things that maybe are have more pressing concerns are addressed, I think you'll see them being reopened. And so that's how I sort of see this process playing out in that case.
Okay. I think, if I combine both questions, your question is particularly significant implications for her questions as well. Let me answer the questions in this way. I think the ultimate goal, one of the ultimate goals of the transitional justice is social integrations between the victims and, between the peoples, especially in Korea, between South and North Koreans. In order to achieve this kind of social integrations, I think ideology does not matter. But however, because of the big differences of ideological differences between North and South Koreans, as I said, both Koreas want a special international tribunals to deal with this kind of transitional justice, particularly criminal justice. So if we do not establish a special international tribunal, then, I think the communists might be another victims of the internal, domestic criminal justice procedures, I think.
I think there's no guarantee that South Koreans and North Koreans are going to want the same thing. North Koreans whose family were wiped out, he's going to want revenge. He's going to want local tribunals. He's going to want firing squads or hangman's noose. Whereas the South Koreans might have a more nuanced view of what justice is.
It's not what we heard yesterday. And I know that from Argentina, and there's that play, Ariel Dorfman, Death of the Maiden, where there's often victims, are struggling themselves with different sense of what will make them feel better, what will add to. So there are many, there's a writing by Jean Améry, a survivor of the Holocaust, who commits suicide decades after he's released from the camps. In the first decade, he gets support from the community. They agree with his political reality that that war crimes and crimes against humanity have been committed by Germany. But 2 decades later, by the time it's 1968, there are debates about statutes of limitations, and he says no one shares his reality. He's invisible on the bus. And so it's this really interesting question of how much will, is South Korea, how much will others in civil society support that and acknowledge, not just some human rights groups and not just the victim's family, but how much of this will become, shared political discourse. I think that's really important.
Okay, yes.
I guess this question is for anyone. Both Korea as a member states of the United Nations, how it would affect in terms of we are dealing with such war.
Situation.
And all of you touched upon a very important issue, which I agree, the role of leadership. Say that who is going to take charge and who will possess the capability to say this is going to be 30 to 40-year process. We have to set priorities straight, and some issues should be weighted. Who will do the job, and where does the legitimacy and power comes from? Domestic actors or international actors?
Anyone who can?
I mean, it's hard to. Yeah, I mean, it's hard to predict. Obviously, I think a mixture. I think that it'll probably be a pretty largely domestic effort, but there'll definitely be international advisors, I think, brought on, in part to give it the sense of impartiality that we've already mentioned. Who has that authority? I don't know. I think it's hard to predict, but I think, as we've talked about, Desmond Tutu and others, that's important. But oftentimes those figures don't emerge until the time.
But it's a different case than South Africa. You have two entities, North Korea and South Korea. South Africa does not have North South Africa and South Africa.
They had the ANC.
But still, I think that
Germans did not have the Korean War. They did not fight each other.
Well, each case is unique. I mean, I think we can get into that.
I think each case is unique, but I think the key is really having a national discussion, in terms of the way forward. I mean, even processes that seem to have been smooth, like the South African process, had a lot of hiccups. I mean, if you recall that South Africa even had CODESA 1992, which collapsed, because the parties were fighting, actually, basically, disagreeing totally about what should happen, even about how to address the question of reconciliation and all that. And that's why even the question of revenge, I mean, I think in the end it's the question of big picture. I don't think that it's that uniform that all victims want revenge. I think that one has to have this debate, and then the process will arrive, and that's arise from that, and I think that's what is important. That the process is a national debate, and how you encourage that, I think, has to be done through NGOs, through all kinds of processes. As Asan is doing now, I mean, this is part of the process to actually understand what could be done and what's possible.
Yeah, just if we think of the charismatic leader in Burma, I think she played a very big role in being able to galvanize support for change in Burma, and she, had particular relationships with the military and was able to, get some kind of support and disaggregation within the military. And there are, we heard yesterday from survivor from the camps, Václav Havel, the folks that had the most authenticity and prestige and were able to argue for limited expectations in terms of retribution and more emphasizing going forward were those who themselves were victims of the regime and had figured this out in terms of their own importance. That doesn't mean that there aren't victims that might be against that kind of, you had that in South Africa as well, the family of Steve Biko. Victims' justice and the interest of victims isn't going to be the same as a determination made in a consensual way or democratic way. But those figures, I certainly was very impressed by the presentations we've heard from the region already, and I think there is leadership. It's just a question of getting the word out and shaping it. Yeah.
Okay, I'm going to entertain one more questions. You have questions? Okay, yes.
I wonder if the two Koreas have found any common ground in any international organization. One that comes to mind, among the many that exist, is the International Tribunal for the Law of the Sea. Not that that would be a place that the two Koreas could find, but are there any international organizations in which the two Koreas participate and have found common ground?
With regard to these questions, well, actually, North Korea signed the United Nations Law of the Sea Convention, but not ratified the United Nations Law of the Sea Convention. So that's why, well, North Korea cannot appear on the international tribunals for the law of the sea. However, well, if you look at, with regards to common grounds, you are right. You are definitely right. In all other international forums, we have just debated all kinds of aspects. So I don't know whether this comes from the ideological differences between South and North Korea, or, well, I mean, the differences of the interpretation of democracy or other democracy or freedom. But the thing is that this will deepen the concerns among South Koreans, because we don't have anything to share with regard to the values of democracy and freedom.
I brought up the tribunal to the law of the sea because the current president is a former Japanese diplomat who served at the embassy of Japan
Yes, right.
and has been a leader in advocating closer cooperation between Tokyo and Seoul. And it's probably one of the 2 or 3 most outstanding foreign service officers of Japan in the last 60 years. His name is Shunji Asan.
Yes, Shunji.
Very well known in Japan politics.
Yes.
So I'm thinking of guys like that who could at least, to a certain extent, personalize and use existing relationships to find common ground that could be built on for other purposes.
For instance, well, with regard to the natural resources and maritime areas, well, North Korea has deep common interests in dealing with, well, natural resources because, well, if you look at the Northeast Asian countries situation, there is no maritime delimitations between, well, the states. So there must be a certain joint development concept should be, well, enshrined in this region. So in this respect, I think, well, North Korea may have common interests or common, well, understandings. But other than that, well, I couldn't find any. Okay. All right. Yes. Thank you very much. For this.
Thanks so much.
This concludes our morning session. We will now move to our lunch break. Sandwiches and refreshments available outside.
Very good.